Now we will be discussing about chapter 13 of the Book of Father Bernas, which talks about the peaceful settlement of disputes. So let's define what international dispute is. Not every disagreement is a dispute. A dispute is an international dispute if there is disagreement on a point of law or fact, a conflict of legal views or interest between two persons. So basically, an international dispute is considered only as such if there is conflict, perhaps of the source of law. Let's say, for example, if there is an interpretation or confusion as to the interpretation of the law, or if there is ambiguity or the message or the definition of the contents of the agreement is not that clear. And sometimes it's the reason why there is a conflict or there is a dispute. Now, the dispute comes in because one party is asserting another interpretation and the other party is asserting a different interpretation, which of course should be favorable on the end of that particular state. So when there is dispute, the international community have delineated and established rules and policies in order that the states may have an option and the preference on what type of peaceful settlement are they going to choose in the resolution of that conflict or dispute. So again, what are the examples of them? Disagreements over the interpretation of a treaty, state boundaries, or about the state responsibility. So one concrete example for that would be the case of, let's say, the case of Nicaragua versus Uganda, the case of Philippines and China over the West Philippine Sea, the Lotus case, any case which involves, of course, the sovereignty and which affects the security of a nation. So under Article 2 of Paragraph 3 of the UN Charter, what does it say? It provides that all members shall settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. So how about the regional organizations, sir? Like, for example, Association of Southeast Asian Nation, APEC, um, European Union, etc. So as I've said, no, it doesn't mean that they are mere regional organizations. They are under already the supervision of the United Nations. That is not necessarily the guarantee. But of course, these regional organizations are given the autonomy to rule within its jurisdiction. However, it must be noted that the provisions, of course, of the charter of that particular regional organization should not be um, incongruent or should not be contravening the customary international laws. Okay, so we already know that. So in fact, in ASEAN Charter and in EU Charter, there is also a settlement mechanism in case when there is, of course, conflict or there is misunderstanding between and among states or member states in that regional organization. There is no obligation to settle dispute unless they fall under the categorization of Article 33, which means that those which might endanger peace and security. However, if there is a decision regarding settling disputes, the obligation to settle them is by peaceful means. So one best example for this would be the application of precautionary principle under international law, that when it's most likely applicable in environmental cases or environmental concerns, that when, for instance, let's say there is a problem in Lebanon, assuming that there's an eruption of their, let's say, uh, plant plantation there. So the smoke extended to the neighboring countries or neighboring states of Lebanon. So in that case, it will endanger, of course, the health of the people of the neighboring state. So in that case, when there is misunderstanding and as to the, let's say, for example, the neighboring state is asking for reparation, then they have to settle the dispute or conflict peacefully, right? So peaceful methods of settling disputes under Article 33, the parties to any dispute continuance of which is likely to endanger the maintenance of international peace and security shall try to seek a solution by the following method. So there are actually three methods in order to settle these types of dispute. Number one, judicial. We also have quasi-judicial or non-judicial. So when we talk about judicial, from the word itself, the recourse to the ICJ or other international tribunals. What are judicial courts in the international community? We have, of course, the International Court of Justice, which is under the United Nations. No, it's an organ of the UN. While on the other hand, we also have International Criminal Court, which is an independent body. It's an independent institution. It's funded by the member states, but it's not part of the United Nations. No, always remember that. What's the uh, predecessor of the International Court of Justice was the PCIG. Okay. Um, right now it's called ICJ or International Court of Justice. But again, there's a difference between the jurisdiction of ICJ vis-a-vis that of International Criminal Court. We also have quasi-judicial arbitration. So basically, it's quasi-judicial because it's not entirely um, officiated by judges, but it's parang semi-judicial, or it's quite a judicial but not close. Okay, so there's an arbitrator, for instance, uh to stand in the middle of the two parties, and they have to that arbitrator will ask for the evidence of the other party and the point of the other party, and then arbitrator will decide on the matter. We also have non-judicial um, compromise. One no example for this would be negotiation, mediation, inquiry, and conciliation. So usually, the uh, two parties will just talk to each other, and they will settle their dispute on their own. Article 36, the Security Council may recommend appropriate procedures or methods of adjustment in a situation referred to in Article 33 or in any similar circumstances. If the parties failed to resolve their dispute in the method aforementioned, they shall refer it to the Security Council, and the Security Council will then decide whether they will enforce the procedure of Article 36 to recommend terms of settlement if it deems necessary. That's why what I'm saying is Security Council is the most potent and the most powerful organ of the United Nations. No, although that there are judges chosen in the International Court of Justice to be seated in the International Court of Justice, but should there be failure in the resolution still of that case, because ICJ has no teeth at all. No, ICJ cannot or does not have the enforcement power to enforce the resolution or the the decision with respect to that matter. So Article 8, if the parties to the dispute so request, the Security Council can make recommendation to the parties with a view to a peaceful and pacific settlement. So there's a huge politics right there. No? So if, let's say, who composes the Security Council? We have the P5 or the permanent members of the Security Council. We have France, Russia, China, um, uh, USA, and the United Kingdom or Great Britain. So we also have non-judicial or diplomatic settlement. Negotiation. It is preferred vehicle because states are generally reluctant to submit their disputes to an adjudicatory body. No, aside from the fact that it's cumbersome, it's also non-convenient to the part of the. It's expensive, of course. No, that's one thing, and then it's tedious. The process is tedious, so that's why most, if not all, states would prefer negotiation rather than dealing or perhaps submitting themselves in an adjudicatory body. It's a very flexible method because there are no set rules. It may be at arm's length or face to face, or it may be formalized in a treaty, or a mere exchange of notes may be carried out by diplomatic correspondence, face-to-face dialogue between permanent envoys or designated negotiators. It is essentially a give and take process looking for a win-win situation. Just take a look at the Duterte's administration's conduct with respect to the issue on the West Philippine Sea. So where did of course the two presidents met, and then they talk about it. They have exchanging words. They have diplomatic correspondence. They decided that the president have decided that he will not, impose the decision itself, but rather there should be an economic let's say the Philippine government would allow Chinese government to use a portion of that territory in the West Philippine Sea, and there should be an economic cooperation between these two nations. So that's what an example of this negotiation. Okay, it's a bilateral negotiation. However, the problem is that negotiation between two parties will be effective only if the two parties has an equal status, as an economic and political status. The problem with that is when there is negotiation between two different nations, although they are both sovereignty, there are both sovereign. There's no question to that. But what I'm talking here is the fact that if the two countries negotiate with each other and the other party is powerful and the other one is a mere developing country, then uh, my submission is that it's risky. It's a risk on the part of the developing country or the not so powerful party to engage in a bilateral talk or bilateral negotiation with other state. No, it's okay kung parehas lang silang powerful, parehas lang silang um, mayaman. Okay, just like for example the case of, let's say, Russia US conflict, for example. No, it's way better if they would talk under the bilateral negotiation process, because they are not equally the same, but the difference is not that close compared to a developing country. Okay, vis-a-vis a first world country, considered to be a first world country. Okay, so good offices, preliminary step in negotiation, a neutral third party brings the two parties together as an initial step before judicial settlement is referred to. This is what I'm saying. No, there's an arbitrator. Okay, arbitrator will stand in the middle of the two parties. He's a neutral third party, and then he or she will listen to both the contentions of the parties, and then he or she will decide based on those information. Mediation involves assistance by third parties acting as a bridge between the two disputants who do not meet or who may sit with the two parties at chair meetings, suggest solutions, and hold them to a resolution. The mediator is approved of by both parties. Okay, so usually arbitration is actually also founded on an agreement, no, that when the parties, for example, a group of state, let's say, they have signed to an agreement that it's sort of organization, and they have to settle their disputes or differences there. Inquiry, a fact-finding conducted by a group or by an institution, frequently resolves dispute on questions of fact when applied for with the consent of the parties. So there is still a consent between these two parties, and it's unlike in mediation and in arbitration, it's not conducted by an individual, but it's conducted by a group or by an institution. We also have conciliation, a more formal technique where disputants agree to refer to the controversy to an individual, a group of individuals, or an institution to make findings of fact and recommendations. Parties generally do not agree to be bound by the findings made, but this clears the air. Okay, so it's not binding at all, right? The binding settlement of dispute on the basis of law by a non-permanent body designated by the parties, the composition, jurisdiction, and procedure employed or agreed upon by the parties in a compromise, they arbitrate. So, unlike in a judicial process, no, in a judicial body, there is specific rules made by the court itself, or the court itself has already a rule of its own. So there are set of rules. In arbitration, the parties can make their rules. Okay, what we meant by the rules are the procedural rules, no, like the submission of, let's say, affidavits, the submission of evidence, so on and so forth, the period for its compliance, and so on. Okay, so these are determined and of course agreed upon by both parties. States are not required to submit to arbitration unless there is an agreement making it compulsory. So again, um, when we say arbitration, it's not automatic. There should be an agreement first. Okay. Distinguished from judicial settlement, what's the difference? Arbitration is more flexible and parties have a greater say. In a judicial settlement, you cannot really, there is no flexibility. You have to submit to the rules of the court, of course. Okay. So let's say, for example, period for filing, uh, what else? The manner of submitting your evidence, the matter of arguing in the judicial court, in a judicial body. These are all are written in the rules. So there's no flexibility at all. Unlike in arbitration, it's much, much more flexible. Okay. And in fact, the parties have the right to choose what type of rules are they going to follow. What are the three types of arbitral agreements? We have arbitration clause that is incorporated as a part of the treaty. So let's say there is a treaty and then sa pinakababa diha na ay arbitration clause na should there be conflict between the two parties, between let's say between Malaysia and Indonesia, it should be resolved and the parties thereof are bound to submit themselves to the jurisdiction of arbitration body or arbitral tribunal. Arbitration treaties were the sole function of the treaty is to establish methods for the arbitration of disputes. We also have ad hoc arbitral agreements. Arbitral decision apply international law unless the parties specify other. When we talk about ad hoc, usually it's appointed. No, it's a group of, let's say, arbitrators will be there to decide and to listen to the contentions of the parties. However, arbitral decisions are often challenged pursuant to the following grounds. We have arbitral body exceeded its power, corruption on the part of a member of the body. What if binayaran lang ng isang party yung arbitrator? So that's one issue there. There was failure to state the reasons for the awards or a serious departure from a rule of procedure. Kasi nga, walang fixed na batas, walang fixed na rules. Kanya-kanya, no, or ang partido sila lang gagawa ng rules nila, no, in the resolution of the case. So that's the again, no, sometimes it could lead also to another problem. The undertaking to arbitrate compromise is a nullity. So let's say, for example, there's an abuse of power, or let's say there was no due process at all. Okay, so that's one of the reason for its nullity. Or there is force, perhaps there is use of threat, for example. Grounds of domestic courts to refuse to recognize arbitral awards. So when can we say that a domestic that the domestic court can refuse na, oy, we do not recognize that arbitral award? Because when the arbitrator will have a judgment, no, kanang award na you have to go to court para i-enforce na, no, you have to submit it to the court for the enforcement. The agreement to arbitrate was not valid under applicable law. No due process. Award deals with matters outside the arbitration agreement. Arbitral tribunal is contrary to the agreement of the parties. reward is not yet binding, has been suspended or set aside by the competent court. So let's say, for example, Indonesia and Malaysia, they have agreed that they would submit on arbitration, and the arbitrator have um, released its judgment. And then after that judgment, you cannot automatically enforce that. You have to go to court first, no, for its enforcement. Okay, but sometimes the domestic court, and these are the grounds that it will not recognize arbitral awards, no, such, again, example, walay due process. So let's talk about International Court of Justice, although we will deal with this when you reach fourth year under international organization. Um, we'll discuss them fully with cases, but okay, let's discuss some of the salient points of ICJ. Okay, this is a judicial manner. It's a judicial process of resolving cases in international law. The UN's principal judicial organ, it is the successor of the Permanent Court of Justice, PCIJ, IJ, which was established by the League of Nations and came into being through the statute of the court. So PCIJ ni siya dati, no? And now it's ICJ, pursuant to the establishment of the United Nations. The UN are ipso facto parties to the statute of ICJ. However, being parties to that statute does not mean acceptance of its jurisdiction. So it doesn't automatically follow na if you are a member, then that would mean an implied acceptance of its jurisdiction. Again, consent is necessary. Consent is fundamental in the acquisition of jurisdiction over a state party. Okay, it just allows the possibility because only state parties may be parties in the court. What's the cardinal rule? States cannot be compelled to submit disputes to international adjudication unless they have consented to it, either before a dispute has arisen or thereafter. They may also limit their acceptance to certain types of disputes and to attach various conditions or reservations to their acceptance. Okay, you can also have reservation. Okay, we will submit to that, but we would like to have a reservation on this particular matter. Okay. Composition of the court. We have independent judges elected regardless of nationality. But of course, if your state has become the state party, no, it would not be proper that your judge, no, will sit there as one of the independent judges. All right. So how many judges? It consists of 15 members. Note, 2 of whom may be nationals of the same state. Okay. A member is a national of a state where he or she ordinarily exercise civil and political rights. The court may form one or more chambers composed of 3 or more judges to deal with particular categories of cases like labor, transit, and communication. So it's like en bank and tawag nito, the SCN bank or by division, no? Kasi sometimes mag division kung 3 or 5, no? Mag-divide ang mga justices rather to decide on a certain matter. But sometimes, no, it's en bank. When we talk about en bank, lahat ng 15 justices ng Supreme Court will judge on that particular issue. So the issue on possible partiality, judges of the same nationality as one of the parties shall retain the right to sit in a case before the court. Is the court includes upon the bench a judge of the nationality of one of the parties. Any other party may choose a person to sit as judge, preferably from the list of persons nominated as candidates. So what are the type of jurisdiction of the court? We have contentious, no, contentious cases. Such jurisdiction of the court over all cases which the parties refer to it and all matters specially provided. This is also one of the differences between International Criminal Court and International Court of Justice. In International Criminal Court, the subject of the jurisdiction of the court is individual, an individual or are individuals. Okay. So let's say, for example, there's a war crime. It's a crime against humanity. You do not bring the case before the ICJ, but Since it involves an individual, then you must bring the case before the ICC. However, on the other hand, when we talk about ICJ, the subject of jurisdiction there are not individuals, but the subject are states. So usually, maritime maritime cases, maritime conflicts, no? Yan ang mga example. Territorial disputes, no? Ganyan. So if the concern is between state versus state, then you go to International Court of Justice and you don't go to ICC. Because ICC, just like what we have now, no, the case of President Duterte, he was charged and he is investigated currently by the International Criminal Court for alleged violation of crime or the crime against humanity. No, it was charged against him. Advisory, the court may give an advisory opinion on any legal question. No? So, anong mabibigay ng ICJ? Hanggang advisory opinion lang. Okay. So let's take a look at some of the cases here under optional system. The aerial incidents case, US versus Bulgaria. Well, the issue here is whether or not Bulgaria has submitted itself to the court's jurisdiction when it's alleged that Bulgarian military failed to take actions necessitated by international civil aviation agreements when Israel airliner entered into Bulgarian airspace and was shut down by them. So you see, no? So tirahan diretso ang Israel airline. Okay. The case was dropped by the US. The objections of Bulgaria must be noted, particularly its objection, which called upon the grounds of reciprocity and consensual basis of ICJ jurisdiction by invoking the Connolly Amendment Reservation, exempting from ICJ jurisdiction matters cognizable within its internal competence. Because it can be, we always, it's sort of hierarchy of jurisdiction that you don't go directly to the ICJ or to the international courts or international jurisdiction. You have, if it can be resolved within your jurisdiction, within its internal competence, then so be it. No. Also, the Nicaragua case, whether or not the U.S. accepted jurisdiction of the ICJ. In 1946, U.S. declared its adherence to ICJ jurisdiction, noting that it would be terminated after 6 months notice given to UN regarding its expiration. After figuring out that Nicaragua would bring the situation to court, okay, they deposited the 1984 notification with the UN. The court ruled that Nicaragua was a state accepting the same obligation as the US is in its acceptance of the court's jurisdiction under the statute of PCIJ, and that the US could not defy its own declaration by not complying with it 6 months notice provision. So, of course, no, the UN cannot evade its liability because, again, they did not comply. They did not comply with the 6-month notice provision. Maro po ng US. Case of East Timor, the case of Portugal versus Australia. The issue here is whether or not Portugal can bring an action against Australia regarding the zone of cooperation, which is the subject of the treaty between Australia and Indonesia. The court ruled that the actual dispute was between Portugal and Indonesia and could not continue because Indonesia had not accepted the jurisdiction of the ICJ. Again, no, despite the fact that they are both state parties to the United Nations, it is not a guarantee, and we cannot compel the member state to submit itself before the jurisdiction of the ICJ because consent is fundamental. You cannot acquire jurisdiction without consent, without the consent of that state or without the consent of that state party. The court can indicate and impose any provisional remedies to preserve the rights of either party pending final decision of the court. The same fact set as above Nicaragua cases, given the circumstances, the court deems it appropriate to grant provisional measures and emphasizes that the grant does not prejudice the eventual decision of the main case. Okay. The intervention of a third-party state in dispute between other states on the basis of its interest in the outcome of the case. That's what we meant by intervention, no? So you can intervene if you have an interest over the issue. Its interest must be of a legal nature and not merely kanang kuan. Not merely conditional or not merely tawag nito kanang immaterial, no? So when you have a case, when you have a concern, should be a material nature, no, na dapat na jud kay interest dira. Otherwise, of course, you'll be violating the law, no. Request for intervention is submitted to ICJ, so you have to ask again, no, the consent also of the court before intervening. So in the case of Nicaragua intervention, okay, on the case of El Salvador versus Honduras, whether or not Nicaragua can intervene in the dispute between El Salvador and Honduras regarding the protection of its legal right in the Gulf of Fonseca. The court ruled that Nicaragua was able to show proof that they had interest of a legal nature. Let's say, for example, there's a conflict of territorial dispute and the territory also of the state who intervenes is affected, then he can, or it can rather, it can legally intervene in the case. Okay. So obligation to comply with obligations, the ICJ's decision has no binding force except as between parties and only in respect of that particular case. The judgment is final and without appeal. So when it decided for a certain case, that would be final, no? However, the problem, as I've said, is the enforcement. Division of judgment can only be made upon discovery of a new fact of such a nature as to be a decisive factor which was unknown to the court and also to the party claiming revision, provided the ignorance was not due to negligence. Okay. So can you reopen the trial or can you reopen the case? Yes. On the ground of the existence of the new fact and recognizing that it is of such a character to lay the case open to revision. So what if after the decision, nag-decide 2010, tapos you have filed your intention to reopen the case in 2022, then the period has already lapsed. So you cannot reopen you cannot reopen the case anymore. So how about enforcement? Member states must comply with the judgment. If not, the aggrieved party can appeal to the UN Security Council, which can make recommendations or decide upon measures. So it's not actually the ICJ who enforces the rule or enforces the law, but it's the UN Security Council. That's the problem if your kalaban is a member of the Big Five or the P5, because they are the ones who will be deciding whether to forcefully enforce that judgment or not. Okay, so that's the problem. Other active international courts, we have European Communities, European Court of Human Rights, the Benelux Court of Justice, and Inter-American Court of Human Rights, the ICC in 2002. Okay, and that's the end of chapter 13. Thank you.